Hello again, Dan Alasso, Making History, and it is another crisp early fall day in Minnesota today, so I am wearing my new flannel shirt. I'm about to get all my flannel shirts out of a box and prepare for winter. But what I wanted to talk about today is the other day, I was reading or watching something that referred to Supreme Court Justice William Rehnquist's 1977 dissent in the case of First National Bank of Boston versus Bellotti. I've been racking my brain, but I can't remember exactly where it was I saw this reference. So I apologize for that. But Rehnquist, who lived from 1924 to 2005, was actually an associate justice at the time of this case and this dissent. After serving in the Army Air Corps during the Second World War, Rehnquist had gone on to Stanford University on the GI Bill and gone all the way through from undergraduate through the law program. He was understood when he was nominated to the Supreme Court in 1971 to be way to the right of Patrick Buchanan. So as a conservative, he took a very narrow view of the 14th Amendment. Often, Rehnquist's conservatism resulted in opinions that seemed to resist the court's impulse to legislate from the bench to achieve progressive social goals. It's unclear to me, from the admittedly very limited reading that I've done, whether he was really guided just by his understanding of law or whether he let his personal worldview enter into things like his conclusion that Plessy versus Ferguson was right and that Roe versus Wade was wrong. One thing that he did do, though, was to suggest that the rights of corporations were not as extensive as those of living people, as a broad reading of the 14th Amendment has been used to assert. In his dissent in this particular case, he said, quote, "Early in our history, Mr. Chief Justice Marshall described the status of a corporation in the eyes of federal law. A corporation is an artificial being, invisible, intangible, and existing only in contemplation of law. Being the mere creature of law, it possesses only those properties which the charter of creation confers upon it, either expressly or as incidental to its very existence. These are such as are supposed best calculated to affect the object for which it was created." And then he cites Dartmouth College versus Woodward, etc. A very important decision from 1819. Rehnquist said that as creatures of the law, corporations were, quote, "created by the Commonwealth only for the limited purposes described in their charters and regulated by state law. Any rights, which I would call privileges, that a creature of law might have were not natural rights, because the creature isn't natural. They were, rather, incidental, in Rehnquist's word, or necessary to the function for which the corporation was chartered. So a corporation that used capital property, for example, to manufacture something, had to be protected by due process from gratuitous seizures of that property. Or a corporation that ran a newspaper had to be granted freedom of speech so that it could do its job appropriately. But although a newspaper corporation ought to have the right to endorse a candidate in its editorial pages, that didn't mean that a corporation, newspaper or otherwise, had a right to make campaign contributions, Rehnquist said. He said, "A state grants to a business corporation the blessings of potentially perpetual life and limited liability to enhance its efficiency as an economic entity. It might reasonably be concluded that those properties, so beneficial in the economic sphere, pose special dangers in the political sphere." Yeah, it would seem, wouldn't it, that the gift of immortality maybe ought to come with some limitations. And in many cases, Rehnquist said, it might be argued that liberties of political expression are not at all necessary to effectuate the purposes for which states permit commercial corporations to exist. So especially in situations where expressing political opinions is not incidental, not necessary to the corporation's function as expressed in its charter, maybe it ought to refrain. Now, I'm not sure what I think of Rehnquist overall. I'll have to do a lot more reading that I don't really have time to do at this moment. But I did think that this dissent was fascinating. It would be really interesting to explore that whole idea of chartering corporations for particular purposes and then limiting their privileges to those necessary for them to actually perform those goals, rather than just imagining them as immortal, artificial people with all the rights of humans, but forever. It might even be interesting in the same way that some conservative Doge enthusiasts have suggested writing laws and regulations with sunset provisions, that maybe corporations ought to be mortal, like the rest of us. I imagine that this won't be possible to change from the top down, but maybe interested consumers could express a preference in the market. The ESG environmental movement was mostly performative BS, I think, but I'm not sure that that necessarily means that no challenge to the ways that corporations operate is possible at all. So maybe in the future, some interested anti-monopoly types might pick up this thread and run with it. In any case, this was something that I found interesting this week. I hope you did too. Thanks very much for watching, and I will see you again very soon.